my name's Luke Smith. I'm a Minnesota workers' compensation attorney, and I've done workers' compensation litigation for most of my legal career. I've represented businesses large and small. I've represented insurance carriers, and currently I represent mostly employees in workers' compensation litigation. I've been asked to share the top 5 mistakes that businesses make without legal counsel. So here's the top 5 from the perspective of what I see coming in the door with small businesses in my practice. So number one would be inadvertent mischaracterization of employees as independent contractors. So a lot of people intuitively think that a person that's performing a service for hire is an independent contractor as long as that's what everybody agreed to. And that's not always the case. So decision makers like courts, insurance companies, and administrative agencies are often going to determine whether a worker is an employee or an independent contractor based on, what type of work they were hired to do, how many other companies they provide services to, how much they were paid, how they were paid, how much control they had, how much financial risk the worker was taking. And they're going to decide substantively, is this an independent contractor relationship or is this an employer employee relationship? They're not necessarily going to follow the agreement between the worker and the business. And so even an inadvertent mischaracterization of an employee as an independent contractor can have some pretty serious financial consequences for the business. You can see potentially trade license suspension or revocation, liability for damages, penalties, retroactive insurance premiums. Mistake number 2 would be failure to properly insure, and mistake number 1 often begets mistake number 2. So something that I'll see pretty commonly is a small business that believes that it does not have any employees because all of the work is being tasked out to independent contractors. And as a result, the small business may not carry workers' compensation insurance. And so just because a business owner believes that the business does not have any employees does not necessarily make that accurate, for one thing. And for another thing, it does not necessarily mean that one of those independent contractors isn't going to sustain an injury and then claim that they're an employee. Workers' compensation insurance policies and other similar types like commercial general liability insurance, they not only do they cover damages for, claims that are brought against the business, but they also, the insurance company will appoint an attorney to defend against those claims and cover the attorney fees. And those types of policies, depending on the industry and the size of the business, can often be pretty affordable. Mistake number 3 would be handshake agreements. So business litigation is usually based on some type of agreement. It might be between the business and an employee, the business and a subcontractor. It might be between shareholders or, between the business and a customer. But in any event, usually there's some kind of agreement that's involved. And if that agreement is not in writing, the only real way for a court to decide what the agreement was is to take testimony at a hearing or a trial and decide based on what the people are saying what the agreement was. So even for the person or entity that turns out to be right, that's still expensive and time consuming, and it still involves a lot of uncertainty. So, written agreements make it much more efficient to resolve conflicts, when they come up. Number 4 would be cash payments. So, like handshake agreements, cash payments are attractive because they're informal and they're easy. However, they do not make for a clear record. So, when a business pays contractors or employees in cash, it's very difficult to prove how much they were paid for what or when, other than by taking testimony at a trial. So if a dispute arises out of that business relationship or that transaction, where there were cash payments being made, it's pretty likely that the litigation is going to be more costly and more protracted than if there were invoices, checks, and accounting records. Mistake number 5 would be delay in consulting an attorney. So another thing that I see coming up is a business will start receiving court filings in the mail, and the business owner or officer will sometimes choose to spend some time trying to resolve things informally, with the other party instead of, having to go through the whole court litigation process. And so as a result of that, they may not necessarily immediately contact an attorney. And the drawback to that approach is if there's court filings or court papers are being served on a business, it's pretty likely that those filings are creating deadlines to, respond to the litigation, to investigate, to do discovery, and those deadlines are often pretty short and pretty strict. So, any delay in contacting an attorney, especially after court filings are being received in the mail, has some risk of placing that business at a pretty severe disadvantage in the litigation. So those are the top 5 mistakes that, at least that I see in my practice. I hope that's been helpful, and thank you very much.